Hello. Am I audible to the bench? Does the council seek permission to address the bench collectively as your lordships and individually as your ladyships and your lordships? The council is here in the matter of Flash Retail Private Limited versus Union of Sindhu Pradesh and others.
Why do you need to address us as lordships and ladyships? You can just address us as the court. That's a more gender neutral form of address.
Okay, sure, your ladyships. I'll keep that in mind. The council is here in the matter of Flash Retail Private Limited versus Union of Sindhu Pradesh and others. I shall be addressing the issue 1 and 4, and my co-counsel shall be addressing the remaining issues. That is issue 2 and issue 3 and 5. With the due permission of the bench, the council would like to state the jurisdiction. The council for the appellant Flash Retail Private Limited humbly submit to the jurisdiction of the Honorable Supreme Court of Sindhu Pradesh to initiate the present appeal under Article 136 of the Constitution of Sindhu Pradesh. With due permission of the bench, the council would like to brief the facts about the case. The case deals with Sindhu Pradesh quick commerce sector, which is a business of delivering groceries and everyday essentials within 10 to 15 minutes. Major companies in these sectors include Flash Retail Private Limited, Jeepmat, and Turan Delivery. Flash Retail in this sector is a leading quick commerce platform that connects customers with independent sellers via the Flashcard app. It operates on a marketplace model funded by the FDI and does not own inventory. However, multiple regulatory concerns emerge. A. The ED alleges violation of the FDI norm under FEMA controlling inventory and pricing. B. Guidelines banning 10 minutes guarantee and imposing minimum baseline pricing were proposed. C. Competition Commission launched a probe into predatory pricing and exclusive agreement. D. Allegations for dark patterns, misleading advertisement, personalized pricing, surge pricing tactics. E. Allegations were raised regarding algorithmic transparency and user manipulation. These matter involving 5 key constitutional and regulatory issues are now before this honorable court. With the due permission of the bench, I would like to advance with the issues. Much obliged. Issue 1 that deals in whether Flash Retail violates FDI policy by effectively running as an inventory-based model instead of a marketplace model. The council humbly submits that Flash Retail operates as a pure marketplace platform and is in full compliance with the Sindhu Pradesh FDI policy, and it does not operate as an inventory-based model instead of a marketplace. To support my arguments, I would like to argue in fourfold facets. Firstly, I would like to illuminate on the definition of an inventory-based model provided under Foreign Exchange Non-Debt Instrument Rules 2019 and Consolidated FDI Policy 2020 as follows. Under these rules and regulation and policies, inventory-based model of e-commerce is defined as an e-commerce activity where inventory of goods and services is owned by e-commerce entity and is sold to the consumers directly. And the marketplace model of e-commerce is defined as an information technology platform by an e-commerce entity on a digital and electronic network to act as a facilitator between buyer and the seller. Through this definition, it is clear that ownership of inventory and direct consumer sales are the essential for clarifications under the inventory-based model and Flash Retail, essentials for qualify as inventory-based model or a marketplace model. Flash Retail does not fulfill any of these essential. The inventory belongs to third-party sellers such as lean basket traders and quick supply offices limited, who are legally independent Sindhu Pradesh entities, and the goods are not directly sold by the Flash Retail to the third party. Secondly, Your Lordship, the Flash Retail ancillary services like warehousing and logistics are expressly permitted under FEMA Rules 2019 as well as the Consolidated FDI Policy 2030. It is provided under para 15.2.3 clause Z that e-commerce marketplace may provide support services to sellers in respect of warehousing, logistics, order fulfillment, call center, payment collection, and other services. Thirdly, even the allegations of breach of 25% vendor cap, which was alleged by the respondent in this case, was a temporary pandemic related surge and does not reflect any structural violation of the policy, Your Lordship. And fourthly, Your Lordship, the pricing discount that is alleged against us, which constitute to have an indirect control over the inventory model. These pricing discount in questions are bona fide promotional rebates, squarely falling within the permissible marketing expense. This cannot be a price setting at seller level. Therefore, there is no factual or legal basis to treat flash retail as an inventory-based model. The appellant is operating within the permissible bounds of the marketplace. Your Lord. First para, Your Lordship. Sir, Your Lordship, page number? Page 4 and? Yes, Your Lordship. It reads, Your Lordship, when flash retail raised successive rounds of foreign capital and allegedly diverted funds to build its warehouse stock and subsidize consumer prices, thus violating conditions under which approval was granted, Your Lordship. Yeah. Your Lordship, it's actually not subsidizing the prices, Your Lordship. So what we are doing is that just to promote the business model, which is a very new emerging concept, just to promote this business model, we are providing this discounts to the consumer as a promotional rebate, Your Lordship, and which falls under the marketing expense, Your Lordship. So this cannot be price setting at the seller level, Your Lordship. That is the contention of this.
As long as you are selling something which is below the cost, that's the definition of subsidizing something, no?
Yes,
in the
sir.
market. So the allegation is that you are subsidizing by whatever name you'd like to call it. How do you meet that allegation?
Pardon, Your Lordship, the council have no response to this. Right? Okay. Shall I proceed to the next argument, Your Lordship? The second issue which I'll be dealing with is issue number 4, that deals on whether flash retail apps design practices dark patterns, misleading 10 minutes delivery advertisement, and personalized pricing and discounting strategies constitute unfair trade practices under the Consumer Protection Act. Regarding this issue, it is humbly submitted before this honorable court that the PIL filed before the Talajas High Court in respect of those allegations is not maintainable in this stage, Your Lordship, as it bypasses the statutory mechanisms that is provided under the Consumer Protection Act 2019, thereby violating the doctrine of exhaustion of statutory remedies, Your Lordship. And the Central Consumer Protection Authority had already issued a notice to flash under Section 18 of the Consumer Protection Act, thereby initiating the statutory inquiry into the very issues now raised in the PIL, Your Lordship. However, instead of allowing due process under the Act to unfold, the petitioner had directly approached this honorable court, which constitute premature invocation of res judicatium, Your Lordship. The Consumer Protection Act 2019 itself provides for a comprehensive framework for this, including redressal mechanisms, inquiry procedures, and appeal process, all of which the petitioner have neglected, Your Lordship.
Counsel, I'm sorry, if we understand your submission is under issue 4, that because there was a notice under section 18 issued,
Yes, Your Lordship.
therefore the petitioner here before the Taladas High Court had an alternative remedy.
Yes, Your Lordship.
Who is the petitioner before the High Court?
It's actually a forum, Your Lordship.
It's the Consumer Rights Forum.
Yes, sir. It's the Consumer Right Forum.
And
Your
to
Lordship.
whom has the notice been issued under Section 18?
It's been issued to the appellant, Your Lordship.
It's been issued to
The
Flash
appellant.
Retail.
Yes, Your Lordship.
Now, in a notice to Flash Retail, where under the statutory mechanisms would Consumer Rights Forum have any remedy?
Sorry, Your Lordship.
Your argument is that Consumer Rights Forum had an alternate remedy. And they have not exhausted that remedy, they have moved the High Court straight away.
Pardon, Your Lordship. There seems to be an error from the part of the appellant, Your Lordship.
No, maybe you're trying to substantiate a point. So, what according to you, the Consumer Rights Forum's alternative remedy would be? That instead of coming to the High Court directly, they could have pursued the remedies elsewhere.
Yeah, Your Lordship. It's provided clearly under the Consumer Protection Act. First, there should have. Just a second, Your Lordship. Give me a second. Just a minute. Your Lordship. Yeah, regarding that question, Your Ladyship. First, the investigation by the CCPA should have been exhausted, and if any conclusive proofs comes out of that, the appellant is here entertained to make an appeal under the Act itself. So, without considering all these factors, the opposite party have filed the PIL in the Supreme Court, Your Lordship. That is the jurisdictional ground that I am trying to invoke here.
Then your argument is not that of an alternative remedy being available, but you should say that there is already an investigation going on.
Yeah.
So the Consumer Forum that has approached the High Court should await the outcome of the
Indeed, Your Ladyship. Indeed, Your Ladyship.
So it is not in strict sense of the term, availability of an alternative remedy.
Indeed, Your Lordship. Secondly, Your Lordship, the doctrine of prospective application of law, which is based on the Latin legal maxim, lex prospicit non respisit, that translates to the law looks forward, not backward. The guidelines for prevention and regulation of dark pattern 2023 were introduced recently, Your Lordship. Prior to this, quick commerce sector came into play early and exploded from a valuation of mere $200 in 2021 to projections of 30 plus billion by 2030. Then there was no statutory clarity on legal framework, especially prohibiting user interfaces practices such as nagging, basket sneaking, or roach model design element. Fresh retail practices such as prompting users to subscribe or pre-tick add-ons were common across the industry and aligned with standard marketing and design trends in the global e-commerce system, Your Lordship. To penalize flash retail retrospectively for practice that were not clearly prescribed at the time of their adoption could violate the fundamental principle that laws must operate prospectively, Your Lordship. Every law is presumed not to have a retrospective operation unless expressly stated, as this was also held in the case of G.J. Raja versus Tejran Surana. Also, the maxim of nullum crimen sine lege, nulla poena sine lege applies in the case, as it forbids punishment for an act without the existence of law, which makes the act an offense under any provision of the law, Your Lordship. In the light of this, flash retail past conduct cannot be criminalized or penalized merely because law has evolved. Once the new standards were issued, Your Lordship, the company acted in good faith by updating its apps practices. A clear sign of willingness to comply with law rather than an admission of guilt was one from the part of the appellant, Your Lordship. So, based on this, the council would like to consider all these things and give us a time to exhaust those statutory remedies under the Consumer Protection Act, and then let the matter be decided later on in this court, Your Lordship. If there is no question, I would like to hand over to the co-counsel. Yes, Your Lordship.
Page 14, you'll find it's this bench, or rather this court, which has required that all these appeals and petitions be clubbed together and brought before the Supreme Court.
Yes, Your Lordship.
Then are you trying to say that that order is for some reason required to be recalled?
Sorry, Your Lordship, could you please
You see,
rephrase?
you're saying that we should push it back to the alternative remedy
Yes, Your Lordship.
at the time being, for the time being.
Yes, Your Lordship.
But the order was that all these appeals and petitions should be clubbed together and brought to the Supreme Court. If you see page 14,
Yes, Your Lordship.
it's the last paragraph, appeal before the Supreme Court, second sentence, Supreme Court of Sindh, whatever. Pradesh has now clubbed a series of appeals and petitions under the lead matter, and these include. So, are you trying to say that that order of transfer was not correct and it should be sent back? Can you ask the Supreme Court to do that once they have already exercised their jurisdiction to bring all these matters before the Supreme Court?
No, Your Lordship, indeed, no, sir. The counsel would like to invite the co-counsel on the bench.
Am I audible to the bench? With the permission of the bench, the council would like to address the bench collectively as your honors. And the council would be dealing with the second issue, that is the constitutional question, whether the government proposals which restrict the ultra-fast delivery claims, the 10 minutes guarantee, and imposing a minimum baseline pricing on essential goods sold online violate constitutional rights under Article 14, that is equality, and 19(1)(g), that is the freedom to trade. So the first point of argument is the violation of Article 19(1) of the Constitution, which guarantees to the citizens the fundamental right to practice any profession or to carry on any occupation, trade, or business. But the Council is aware of the fact that it is not an absolute right, and there can be some reasonable restriction regarding the general public interest. But we would like to say that although the respondent, the state, said that this is not a total prohibition of the trade and business, you can still operate. However, we would like to make a distinction that the very essence of a quick commerce entity is the fast delivery that we can make, and that makes us distinct from other e-commerce sectors. And banning that very essence of the business modus operandi of the company is a violation of Article 19(1)(g), that is our right to carry, trade, and business. And secondly, the new rules and guidelines that the government proposed for online retail by the name e-commerce flash delivery guideline as an amendment to the consumer protection. In that case, a blanket ban, we say that it's not a justifiable ban, since
Challenging the draft guidelines, the draft policy on the ground of 19(1)(g), or are you challenging the circulars issued by the local police as violative of 19(1)(g)?
since after the draft policies were made public, even some states regulators have started implementing the policy like banning, and since that we're challenging that policy.
We seek clarity because as far as the draft guidelines are concerned, they are only draft guidelines.
Yes,
and
we're
not
aware.
law. So there is no need for you to challenge its validity at all. If you are challenging the validity of the circulars, then you'll have to clarify whether what is the scope or the grounds for challenging the circulars.
Yes, Your Ladyship, we acknowledge that, but since the draft policy clearly violates our right to trade, and since that circular had been used even before the notification by some police and even by some states with their own authority, they are violating our rights to trade. Since that, we are challenging even the policy even after being notified by the government.
says Bono's city police in an advisory, sorry, just about that. Some state governments, notably Nagatar, issued circulars signaling local restrictions in line with these ideas. It doesn't say the guidelines. So your submission that it was in line, or rather it was the implementation of these draft circulars, might not be correct because it's only imbibing the ideas. That's what has been mentioned.
His Lordship, we acknowledge that the draft policies, since they don't have a legal spirit, is not challenged under the provision of judicial review of the judiciary. But since these proposed rules, which can harm the interests of the company as well as harm the fundamental right of the company itself, since that is the issue with us, we challenge the court. We challenge this issue before the court.
Counsel, I'm sorry, that is not really the issue before us. Suppose tomorrow the government says this draft is discarded, nothing further proceeds on the draft. Then what happens to the adjudication that you want from the court? You want to engage the constitution bench of the apex court to decide on something that is draft? Which is why the question posed to you by the bench was very specific. Are you challenging the draft policy, or are you challenging some of these circulars that are mentioned? You have to be specific in what are you challenging.
The challenge goes to both the circulars as well as the policy. But in the issues, after the framing of the issues by the Supreme Court, only the policy, the draft policy, is being mentioned in the issue.
Is this your understanding? If the court has framed something as an issue, it is necessary for the court to adjudicate on it? Because again, at the cost of repetition, let us point out, it is a draft policy. What happens if, while you are seeking an adjudication from the apex court, the government says, no, we signed the draft? We cannot adjudicate in vacuum.
It is on the speculative fear of violation of fundamental right. And that, I think, yes, Your Honor, you are right to point out that since the draft does not have any legal and authoritative binding on us, the challenge might be premature, and I think that is upon the court to decide.
Can you make a speculative challenge?
I will, okay. And the next point is that the blanket ban that is posed to this ultra fast delivery, it ignores the essential variables, like since a less drastic measure could have been placed. Like
no, I'm sorry, if you say that your challenge is premature, then how do you then come back to the blanket ban? Because the blanket ban is part of a draft policy.
As well as a circular, Your Lordship.
Circulars are very specific. In fact, these circulars could have been passed by the police in normal course of their business and in exercise of their duties, dehoards the draft guidelines. Because what are they? They're simply circulars on and advisories on how traffic is to be regulated and how safety on roads is to be maintained. For that, they don't need to be guided by certain ideas or draft proposals. Right? So we don't see anything wrong with the circulars issued by the traffic police in any case. And they're specific to certain area and to a particular city.
Yes, Your
Language in which these advisories are issued.
Yes, Your Ladyship. The contention of the council is that since it will come a little bit later, but since there exist traffic regulations like jumping traffic red lights is already prohibited and the traffic rules already existed. So due to that, putting a circular ban on this 10 minutes delivery is arbitrary and it's not reasonable, and that's the contention of the council, Your Lordship. The claim of 10 minutes delivery advertisement. Pardon, Your Lordship. Your Lordship, apologies. Since It's an aggregated, we say that it's an aggregated, the circular with the policy. We are confusing with the policy, and it's apologies, Your Lordship.
Can the police not issue a directive in public interest? Because when there is a timeline for delivery, which is just 10 minutes, then the delivery boys usually violate traffic rules, endanger pedestrians, endanger their own lives.
Your Ladyship, we contend that the operation of this kind of model is that small warehouse are placed around 400 to 2000 square kilometers with around stock keeping units which are in close proximity with the customers. Since they are in close proximity with their delivery destination, it makes it plausible that 10 minutes to 15 minutes delivery is plausible, and hence utmost care and utmost diligence is carried out by the gig workers while delivering the products. Also, we say that since traffic regulations are also already present, like overspeeding, jumping red lights, so additional restriction banning 10 minutes advertisement, which is the very essence of our modus operandi, is a violation of Article 19(1)(g). That is the submission, Your Lordship.
How does it violate Article 19(1)(g)?
It's the
How does it violate Article 19(1)(g)? If you don't deliver it in 10 minutes, you deliver it in half an hour. They are not stopping your business.
we are reiterating that, Your Ladyship, the very essence of our operation is the fast delivery. Other e-commerce other e-commerce does the same thing, like delivering in late, like 5-6 days even. But the thing that makes us different is our ultra fast delivery system, which is the very essence.
Is the right under Article 19(1)(g) an absolute right?
No, Your Ladyship, we acknowledge that it's not an absolute right, but since it's a complete prohibition, we would say the advertisement are
There are reasonable restrictions.
yes, the general
They are subject to reasonable restrictions.
but we submit that, Your Ladyship, that it does not comply with the reasonable restriction. The reasonable restriction, the complete ban is unwarranted, is unreasonable. That's the submission of the Council, Your Ladyship.
But your business has not been banned. It's only the delivery time.
Yes, Your Ladyship. The time of the delivery is the very essence, since that is our model of operation. That is why we say that it's a violation of Article 19(1)(g). The terms and conditions are applied. This is provided.
Is it supported by any data, or it's just a promise with terms and conditions as disclaimers?
No, Your Lordship, in the facts of the case, we acknowledge that in some of the cases we fail to deliver within 10 minutes, but it's in exceptional situations, like it might be traffic or due to weather, but in most of the cases we deliver within 10 to 15 minutes.
So can it be a case of misrepresentation where you are not in a position to deliver? You don't have any data to support it. And then in that event, is the police entitled to give out a public warning against such misrepresentation, saying that these are impracticable periods? If sought to be attained, it might lead to accidents.
Yes, Your Lordship.
Where is the police going wrong, and how is your fundamental right being violated?
The misrepresentation is under the contract of the customer and the delivery agent, and the police policy or the executive policy should not come into picture, Your Lordship.
Tomorrow I can contract to murder. Is that your submission?
Pardon, Your Lordship?
Can I contract to murder a third person?
Absolutely no, Your
That's
Lordship.
what you said just now. The police cannot look into a third party contract.
Can look, but the misrepresentation part, I'm talking about the misrepresentation part.
Counsel, the trouble emanates from the premise you are trying to draw and base your constitutional argument on. You are saying my model is to deliver within 10 minutes. And because my model, which sets me apart, is to deliver in 10 minutes, Therefore, my 19.1G is to deliver in 10 minutes. Would that be the correct way to evaluate whether you actually have a right under 19.1G because you believe that it has to be 10 minutes? Tomorrow somebody can say 5 minutes. Somebody can say, no, all my drivers have a right to wear something, which is obnoxious. Or all my, what sets me apart is all my drivers go whistling on the roads, causing a lot of nuisance to everybody or blaring their horns. But that is my model. So ultimately, your definition of your model, how do you connect that to the limits of 19.1G? That is what is troubling the bench. That is what we're trying to put to you. Please try to assist us there. How do you elevate that to your right under 19.1G? You have a right to carry on trade. Please do. But that is what fell from the bench. Do it in 12 minutes, 15 minutes, half an hour. Nobody's stopping you. But your self-drawn premise of it being within 10 minutes is my fundamental right. That is where we have trouble accepting.
Your Lordship, we contend that the gig workers that are working with us take precautions and they do not violate the traffic rules, and they take utmost care in observing the traffic rules. Since
everything that you're saying is a sequitur of this being accepted as something which is valid.
Yes,
we are on the ex ante position. Whether what you are doing, what you're claiming to be a fundamental right, is actually a fundamental right. Is your fundamental right to carry on trade by way of a dark store using gig workers to deliver, or is your fundamental right to do everything you want to do within 10 minutes?
no, the former, Your Lordship, we say that this is an innovative step that we've taken for trade and business, which is an innovative step. And
What about the speed limit, which is imposed by the traffic police in cities, in highways and elsewhere? Then can you also say that imposition of a speed limit is violative of the right under Article 19(1)(g)?
Your Ladyship, we contend that, as I would reiterate, that traffic rules are not violated. We don't overspeed. Our dark stores are located near the delivery destination. Since then, there is no question of overspeeding or violation of traffic rules. May I proceed?
So, have you disclosed any data, as was asked by one of the members of the bench a little earlier?
No, the proposition is silent, as we would all like to submit that even evidence does not suggest
So
that.
you have not mentioned the distance. You have not mentioned the condition of the traffic. You have not mentioned whether it is a populated town or a sparsely populated town. Then without all these materials, how can the court at all entertain your contention, entertain your challenge?
Okay. Your Ladyship, studies, but I would admit that due to the constraint of the time that we had, we could not bring the study document which suggests that all these dark stores are located near 2 to 3 kilometer radius, so we could not substantiate our claim. But since this form of quick commerce operate in that operation, in that form of this system, since then it makes it plausible, Your Ladyship, and without the violation of any traffic rules. With the permission of the bench, I would like to proceed to the next issue.
How does imposition of minimum pricing on essential goods violate your fundamental rights?
Yes, coming to that point. Your Lordship, equality before law implies that amongst the equal there can be no discrimination. That is accepted consensus. But when the state put a restriction on or put a stipulation of a minimum baseline price, they were conditioned into thinking that these brick and mortar vendors are only small vendors. But there are, in various cases, there are brick there are large brick and mortar as well, like the owners of supermarkets. They operate in physical way, but they have the same uh, the same financial reservoirs, financial muscle to support their capital. Since discriminating us just because we are in e-commerce and we operate in online, and this large brick and mortar supermarket owners, this they operate offline, is not based on an intelligible differential. Hence, it's not a reasonable classification, and hence it's a violation of Article 14 of the Constitution. May I proceed, Your Lordship? Okay. So, the proceeding to the third issue, that whether flash retail engage in predatory pricing by selling below cost to eliminate competition, entered anti-competitive exclusive supply agreements, or use algorithmic pricing strategies that could amount to tacit collusion or abuse of market dominance. So first, coming to predatory pricing is understood as the selling of products below the cost of production, but that predatory pricing has to come up with other conditions as well, like dominant position, that the market has to be in a dominant position. And if the company is not in a dominant position, there is no question of predatory pricing that is provided in the law. Since it's submitted that by simply offering a lower price on its own does not indicate this predatory behavior. It is a well settled principle that the presence of intention to gain monopoly through specific agreement is a prerequisite to constitute this predatory pricing. That is, that was the principle that was elucidated in the case of Union of India versus the Hindustan Development Corporation as well. So first, coming to the dominant position. The dominant position, the Competition Commission of Sindhu Pradesh, as well as the Supreme Court as well, has held that there can be no dominance in the position as long as there exist competitors. So with the presence of competent competitors, there can be no dominance in the position. Hence, the facts of the proposition clearly states that competitors like Zipmart and Turan Delivery are well-funded rivals along with this flash retail. So we say that the appellant in this case is not a dominant player, as it faces fierce competition from this its competitors like Zipmart and Turan.
Council, please have page 9 of the Moot proposition. What is the stage at which you decided to move the High Court? And whatever your colleague argued about alternative remedy, rightly or wrongly, how does that not apply to your approaching this court?
Page number 9. This is Your Lordship, the Director General investigation, when it was going on, there was we approached the High Court since we thought that a remedy can be given by the High Court without the delay of the investigation, and we sought the waiving of that investigation since we felt that there was no prima facie case that would suffice, that would be sufficient to state that we are.
But all of this could have been done by the statutory authorities, you agree?
Yes, Your Lordship, we agree on that point.
So then, going by your own arguments, you should not have moved the High Court because there was an effective and alternative remedy which was statutory in nature, which was available to you.
Yes, Your Lordship. But, Your Lordship, we would contend that the DG investigation, it's a cumbersome and a long process which for which we sought the remedy from the High Court, Your Lordship. Since we find that there was no prima facie case, the CCS found that there was a prima facie case, and that's the reason why we approached the High Court, Your Lordship. An exception is a violation of fundamental right, Your Ladyship, and we felt that.
So how do you establish violation of fundamental right in making investigation? Only because it is
Pardon your ladyship.
See page 9, last
Okay.
paragraph. The High Court decision. It says that Mumbai High Court, however, refused to interfere with the CCS's investigation order, citing the Supreme Court's ruling that courts should not readily stop investigation by expert regulators unless jurisdiction is plainly absent. The High Court in March 2025 allowed the CCS probe to proceed. So the exception that is noted by the High Court is that the jurisdiction is plainly absent. In this case, the CCI, the Competition Commission certainly has jurisdiction. Then how do you expect and why do you expect a court, whether it is the High Court or us, to do a fact finding and substitute ourselves in the position of the experts of the CCI?
Your ladyship, the special leave petition that was filed specific to this Supreme Court was against the High Court's order to raise a legal question about how competition law should treat. If you may refer to page number 10, it's not about the fact-intensive questions that we were opposed to. We cooperated with the investigative agency, that is the CCS.
What you're arguing today, that your policies are not anti-competitive, certainly require a fact finding to be done.
Yes, and we are cooperating on that. But when we approach the Supreme Court, it's not about the fact finding, but the legal questions were about how competition law should treat algorithm-driven pricing and the relevant market definition for quick commerce, and that was filed under
Clever
the
drafting will not create jurisdiction where none exists, no, counsel? The fact that you have a lot of FDI and you can have great lawyers doing their job well, that would not create jurisdiction where none exists. So either you address us on the jurisdictional issue. The High Court has said this is the exception and this exception is not made out. So you please address us how that exception is made out and why Constitutional Court should interfere. Otherwise, we'll relegate you to your statutory remedies.
The High Court has held it's the expert body which was looking into it,
and
indicating that we are not expert enough.
yes.
Why do you think that is bad in the light of this alternative remedy argument?
The approach to the Supreme Court is on the larger legal question, Your Lordship. And after the High Court passed an order to exhaust our statutory remedy, we cooperated. We cooperated with the DG's investigation. We submit data on pricing algorithms. And the internal time and the internal communications with investor about pricing strategy. We cooperated. And the special leave petition, the approach to the Supreme Court is on a larger question of law, Your Lordship.
Counsel, answering my brother's question, you are creating more difficulties for yourself. Let me point out. You are saying you have already complied with the High Court order. And now you are saying that I want to challenge the same order before the Supreme Court. How would the two coincide?
The challenge was about, I reiterate, to raise legal questions, Your Lordship. Because this competition law, this algorithm and all these things are new things and innovative things. So since then, we said that how this legal question should, or how this competition law should treat this kind of algorithms and all was the challenge before the Supreme Court, Your Lordship. Can I continue with my argument? Since, as we said that dominant of position, the dominant of position, first we held that as long as there was an existence of other competitors, we cannot be held guilty of dominant position. And the other thing is that our share market our share in the market is only 45%, merely 45%. And the Ragaravan committee report, the Ragaravan committee was formed by the central government to look into this modern competition. It held that even 80% in the share market cannot be considered in some cases as a dominant position. The geographical market is the urban areas, and the relevant product market is a quick delivery. Since the aggregate of the two becomes a market for quick commerce in the urban areas of Sindhu Pradesh. And in that market, we are not dominant, we have competitors. And since we have competitors and our share market is also less, we contend that we are not in a dominant position. And all these questions like predatory pricing, exclusive supply does not come into question, Your Lordships. May I proceed to the last issue, issue number 5? Much obliged. So the fifth issue pertains to the question that whether flash retail users have the right to transparency in algorithmic decision making. That we contend that this algorithmic decision making refers to the use of data-driven algorithms to dynamically adjust the product recommendation, and the prices are based on the demand, the supply, the time, the location, and the user preferences. These algorithmic models that we employ are a result of years of proprietary research, development, and fine-tuning, which represents a significant investment in technology and innovation, in which we consider is a trade secret. A trade secret is defined as a formula or a process device or other business information that is kept confidential to maintain an advantage over the competitors. And trade secrets are not illegal. Trade secrets, although in the Indian legal system, although trade secrets is not yet
Counsel, nobody, you'll agree, nobody is calling your retaining something as trade secret as illegal. So let's be clear with that. The issue here is this, and it's twofold. Issue one, when you argue, you say, I am only a marketplace, and therefore I'm only connecting a buyer and a seller. I have no further role to play. But here you are saying, no, I will also determine the price. So as a marketplace, when your role is definitionally only to connect a buyer and seller, what business do you have to decide the price? That's number one. Number two, there is a clear evidence of price manipulation.
the discount that we offer to our customer is what we call the promotional rebates, and not kind of a discriminatory price that we set for different customers. And discounts are not illegal, and we can provide based on the credentials of our customers and various things, Your Lordship, and that discounts cannot amount to a discriminatory practice or a discriminatory pricing to different customers, Your Lordship.
His question was different. His question is not on discounting. His question on recommendation based on your profiling. So the algorithmic profiling that is being done and which is suggesting differential pricing for different customers, how do you justify that?
We contend that this pricing, that the pricing that we set is based on the supply chain rather than the involvement of the marketplace.
Why should two people for the same product pay different price?
That depends on the customer's credential as well, Your Lordship, and we have to take into account like discount can be given to some customers due to some of their credentials, like a regular customer or something to the our commerce, and such are what we call as a promotional rebate for them.
So you are like CIBIL for e-commerce?
Your Lordship, pardon?
You are like CIBIL credit rating for e-commerce based on
No,
different
it's not like actually a civil score, but even in other e-commerce sector, customers are treated, sometimes discounts are given to certain customers because of like cash in the form of buying various products or buying this amount of products, this number of products, and that in that discounts applies.
What is the discount
The discount
that
is
you're offering?
it depends, Your Ladyship.
It depends.
It depends on the customer's credential, as we said, and on occasions as well.
Would it exceed the cost of the product?
Not absolutely not, Your Ladyship, since the fact if we were selling those things below the cost of production,
Below the cost of production?
we would have gone down. But the facts of the
Then what is predatory pricing?
predatory pricing is the selling of products below the cost by a dominant position in order to abuse or in order to cause an appreciable adverse effect on the competition, Your Ladyship.
So would this not constitute predatory pricing?
No, Your Ladyship, as
If you're selling it at a cost which is below the market cost, the market price,
we oppose to the
or the
submission.
cost of production, the cost of production.
We oppose to that contention that we are selling below the cost of production. Since our company has been the market share as well as the company is growing, it's going uphill. And if we were selling in below price as is accused by the state, we had been gone down and we wouldn't have any profit. And Your Ladyship, I would reiterate that predatory pricing is done by a dominant company, and in that case, we are not a dominant company at all. So, may I have an extension of 2 minutes just to proceed?
Is not being transparent in your pricing policies. One, you have differential prices. Two, the fact sheet says that it's not as if somebody buying frequently from you is getting a discount. It's the other way around. Somebody who's buying frequently from you, you're charging them higher, and on a new account, you're giving a different and a lesser price. So the allegation is that if you have differential pricing, at least the policy should be transparent. I should know that if this is the price at which I am being offered a product, what is the basis for such pricing? How do you answer that?
As Your Ladyship, it depends on the algorithms, and the algorithms of the company is what we consider as a trade secret, which is not disclosable to the public, and that's the reason why such allegations or such question does not arise. So, as the time, if I exhausted the time, may I proceed with the prayer? Wherefore, in the lights of the facts stated, issues raised and arguments advanced, the appellant, Flash Retail Private Limited, humbly prays before this Honorable Supreme Court of Sindhu Pradesh for the following reliefs: that it declared the Flash Retail Private Limited model as a business model operating as a marketplace-based e-commerce platform in compliance with the consolidated FDI policy. Number two, declared that the proposed government guidelines restricting ultra-fast delivery claims and imposing minimum baseline pricing on essential goods sold online are unconstitutional, being violative of Article 14 and 19(1)(g) of the Constitution of Sindhu Pradesh, and accordingly strike down the state guidelines. Number three, set aside the investigation and proceedings initiated by the Competition Commission of Sindhu Pradesh against Flash Retail Private Limited under the Competition Act of 2002. Fourth, quash the order of the Taladas High Court dated April 2025 suspending Flash Retail Private Limited's 10-minute delivery claims and directing an inquiry by the Central Consumer Protection Authority. 5. Declare that Flash Retail Private Limited is not obligated to disclose its proprietary algorithms for users as they constitute digital trade secrets protected under the law, and that the appellant data practices do not infringe upon the privacy rights under Article 21 of the Constitution of Sindhu Pradesh, or may pass any orders or relief as this Honorable Court may deem fit and proper in the interest of justice, equity, and good conscience, and for the act of kindness the appellant and is duty bound shall ever pray.
Yes.
Readings to the bench, the council seeks permission to oppose the time. Much obliged. The council seeks permission to collectively address the bench as the court. Much obliged. If the court is well versed with the statement of facts, the council seeks permission to proceed with the arguments. Much obliged. I, the counsel 1 for the respondents, would be dealing with issue number 4 and 5, while my co-counsel will be dealing with issue number 1, 2 and 3. Issue number 4 specifically pertains to the Flashcart app, the app which is designed by Flash Retail. The issue 4 pertains whether the Flash Retail's app design practices amounts to dark patterns and whether their 10-minute delivery guarantee is a misleading advertisement, and whether their personalized pricing and discounting strategies constitute unfair trade practices. For this, my submission would be threefold. My very first submission is that the design practices of Flashcart app amounts to an Dark pattern. For that, I put reliance on the guidelines issued by the Consumer Protection Authority regarding dark patterns. The Section 18 notice that was given to the flashcard app, it highlighted three types of dark patterns. One was nagging. Uh, According to the guidelines, the nagging is defined as a dark pattern due to which users face an overload of requests or interruptions which is unrelated to the purchase of goods or services and which disrupts the transaction. What flashcard is doing, it is continuously prompting and overloading with requests uh, to sell, to prompt a sale of its deluxe fast membership, which is totally unrelated to the intended transaction of purchase of goods and services which the consumer is trying to make, and therefore it falls within the purview of nagging. Now, what nagging essentially does is puts a cognitive load on the consumers, and how it does that is it constantly prompts, and to escape this cognitive load, what the consumers does, it yields to those requests, and that is why it is deceptive in that sense, and therefore it is a dark pattern which is totally prohibited under these guidelines. The second the second type of dark pattern which is practiced by the design patterns of the app is basket sneaking. Now, basket sneaking is defined as inclusion of additional items, products, services at the time of checkout from a platform without the consent of the user, such that the total amount that is payable by the user is more than the amount payable for the product and services. There are only two exceptions to basket sneaking. One is an addition of free samples, other one is a complimentary service. There is also a third one which is a necessary fee, which is in the nature of taxes and delivery charges. However, what is happening in the current case, the flashcard is pre-adding two products and services. One is an order insurance and the other one is a low value add-on product. None of these products fall within the exceptions as laid down in the guidelines. None of this is a free sample, none of this is a complimentary service, none of this falls within the purview or nature of tax or delivery charges.
Council, please have page 12 of the Moot proposition. We're addressing us on issue 4. You are for the respondent state.
Indeed, Your Lordship.
What is under challenge before the Supreme Court?
How should personalized pricing and dark patterns should be pending with Your Lordship?
Please have page 12 on the top. What transpired before the High Court? One, the High Court said this is all prima facie. Two, the High Court directed the statutory authority to do their job. Nothing more than that. So why should a challenge to that be entertained? And why you as a respondent are not objecting to jurisdiction? Why should the Supreme Court get into all this?
Your Lordship, these guidelines are very novel in nature. They haven't been interpreted as of yet. And if you see practices like nagging, they are very vaguely defined. How much is too much repetition? How much is overloading of requests?
Counsel, I'm sorry, if something has not been interpreted yet, that does not mean the Supreme Court should do it. We rely on the High Courts. The High Courts would at times do a much better job because they would have more time to do it. Very often. Why should the Supreme Court entertain this against an interim order A, and B, you are appearing for the respondent state?
Your Lordship, against the interim order, the appeal was filed by the appellants here. However, we also directly approached the Supreme Court because once this decision was made with respect to the practices of the appellant, the Supreme Court would have defined the law with that respect. And that is why, to clearly establish all the rules, we have approached this Honorable Court so that on a broader prospect, these questions are defined.
please pick up the Constitution of India. Show us under what provision of the Constitution of India does the Supreme Court have this jurisdiction that if a question is arising for the first time, the Supreme Court should settle it. We are the final court, not the first court.
Indeed, Your Lordship. Your Lordship.
There is no precedential reference, is there?
With respect to my argument, no. On the issue of nagging, there is no precedent here. No. Indeed, Your Lordship. Uh, Your Lordship, if I may please request the Honorable Court to answer this question a little later, at the time of the rebuttals or a little later.
Another question we had was that what is the consequence of a Section 18 notice issued under the Consumer Protection Act?
The consequences of a show cause notice wherein the CCPA would start its investigation post a notice.
So for now, it is only for a fact-finding or a preliminary investigation kind of a procedure that you got the notice under Section 18, which is followed by a decision as to whether any further investigation is required or not by a regulator. And then if the regulator finds any faults with you, only then law will follow its course, right? So at this stage, why do you not object to the jurisdiction of the High Court also being invoked? This is still at a stage where only a Section 18 notice has been given, which to my mind does not have any serious consequences, especially if you're so confident about your case.
If I may please answer this question a little later. Could I please clarify the question once again and write it down?
See, you are for the respondent. In this case, it actually makes a difference whether you're for the consumer forum that had approached the High Court or whether you're for the state. But whichever way you need to answer, what is the procedure under Section 18? And considering that it is a very preliminary notice that is issued only for initial fact-finding under Section 18, whether the High Court was also correct in entertaining the PIL, and whether the Supreme Court at this stage should be interfering with the High Court's judgment and doing all this fact-finding exercise.
If I may please proceed to the next issue. Much obliged. Now I would directly come to the misleading advertisement part, wherein the flash cut is guaranteeing a 10-minute guarantee delivery. Now this constitutes a false guarantee in the sense that how this guarantee is being displayed. This guarantee is displayed wherein this 10-minute guaranteed delivery part is shown in a very exaggerated manner, in the sense that font size of it is very large, and thereby they are saying that in the disclaimer we are clarifying it by saying that it is on an average a 10-minute delivery, not uniformly honored. However, it is so visually exaggerated that it has taken the form of falsity. For this, I would also rely on the case wherein a similar thing happened, and a consumer was buying a chimney. This chimney costed 15,000. Now he was buying this on an online portal. Now what happens is this particular chimney had a advertisement on it that we offer a lifetime warranty on this. Now what happens is, on an asterisk they say that terms and conditions apply. However, it is not clearly visible. Now this matter reaches Consumer Protection Authority of Delhi in 2018, And what is held is that this amounts to a misleading advertisement. For the bare perusal of this honorable court, I would like to pass on this judgment, wherein on the last para 13, the order is given, and at the very last page, it is pictorially displayed how this amounts to a misleading advertisement, wherein the terms and conditions applied are given on an asterisk where the fine print is not clearly visible. Towards the last page, para 13 is the order, and at the last page is the visual description of it. In the same case, the Consumer Protection Authority ordered that this was a misleading advertisement and ordered a penalty on the person offering this advertisement. If the court is...
Counsel, you have seen Maggie noodles. Do you think all Maggie noodles get cooked in 2 minutes?
Your Lordship, no. Depends on
Is
the
that misleading?
It is not.
So then how is this?
Your Lordship, but that has the nature of puffery on it. And puffery is a defense to this. This is a false guarantee that we are talking about.
Then how is this different from puffery?
Because this is a guarantee, and puffery is in the sense that it is an exaggerated form of statement. When I say that...
What about Domino's 30 minutes guarantee?
That would fall within the purview of this misleading advertisement.
What action have you taken against Domino's?
Domino's is not found in Sindhu Pradesh, in my opinion. With the due permission, I would now like to proceed to the third pronged submission, which is on personal.
Change their tagline to lightning fast delivery. So we can put it to them that not just in the interim, but they can, if they adopt this lightning fast delivery as their tagline for times to come, then would you have any objection to it?
No, Your Ladyship, then we won't have any objection. We have the
New tagline which is lightning fast delivery.
no, but they are before the court challenging the direction which made them. Then that's totally fine. That won't amount to a false guarantee. Much obliged. Coming to my third submission, which is regarding the personalized pricing part. Now, personalized pricing, how it is happening, is this algorithm is being used to profile the consumers. Now, what is happening is they are profiling the consumers in the sense. Before that, I would like to point out a data breach that had occurred, so that the court may know what kind of data is being collected by the app. Now, for that, if you could please come to page number 13 of the Moot proposition, second last paragraph. I'm really sorry. Dot number 2 of page 13, wherein it states that there were reports of a data breach in December 24, where hackers on a forum claimed to have leaked Flash Retail's user database, which included names, phone numbers, addresses, and order histories of millions of users. Now, what happens is when you have such an enormous amount of invasive data on your consumers, you can obviously profile them. And when you profile them, how it is happening, what the allegation on them is that they are using this profile to price the consumers according to their price sensitivity. Now, those consumers who are very price sensitive in nature and who would not remain with them if the prices are too much low or too much high, but not according to their comfortability. Now, they would offer lower prices to them. However, or lower prices are the prices that would suit them, basically. So now what happens is, for the consumers who are not that price sensitive, who are in the nature that I can pay any amount, for them, they are generating revenue by charging them more. This happens to be a discriminatory pricing, wherein your personal data is being utilized to personally give you a price that would suit their revenue and their profit motive.
Let us ask this, counsel, because you are appealing for the respondent state. Under what provision of which law is this sort of price discrimination illegal?
I would like to point this out from the perspective of Consumer Protection Act, wherein unfair trade practices have been defined, and for that I would like to point this court's direction to the definitional clause of unfair trade practice, which happens to be section 2, subsection 47. Here, at the very point I, the clause I, it states that any price which materially misleads the public concerning the price at which a product or like products, or goods or services have been or are ordinarily sold or provided. And for this purpose, a representation as to price shall be deemed to refer to the price at which the product or goods or services has or have been sold by sellers or provided by suppliers generally in the relevant market. Now, the relevant market here would be the e-commerce platform. What is happening here? What is happening here is that they are misleading the consumers into believing that this is the price that is generally being offered in this market. However, that is not the case. For different users, different prices are being offered. If the two users do not come into contact with each other, they would not even know that they are uh, indeed. In,
And the object of the Consumer Protection Act is to prevent a customer from being cheated, in the sense that you mention one price, but you sell it at a higher price, or you do not mention the price and then sell it at a higher price and thereby cheat the consumer.
in that sense of the term, what is happening is they are misleading in the sense that now the basket sneaking also coming to play here. They are misleading by pre-adding some low value added products, and then they are cheating the consumers by selling the normal product at a higher price by adding a product which they did not intend to buy. In that sense also, it is an unfair trade practice. In that sense, it is discriminatory pricing where two consumers placed in the same position are being charged. Your Lordship, if I may answer this question a little later.
Why would it not be fair competition if a person produces at a lower cost and sells at a lower at that cost at a lower profit?
Your Ladyship, if you have immense amount of supply against another person who does not have this much amount of capital to buy that amount of supply, then what can happen? The person with a huge amount of supply can change the game of the competition by selling by selling those goods at a lower cost. Now, what the other person does not have a choice upon is, if he has to be profitable, he has to at least maintain the cost at which he bought the product. And that is how it is disrupting the competition itself. If the court is satisfied.
So, under which law? You were referring to the Consumer Protection Act.
This particular issue is coinciding with Competition Act also, and I would really like to answer this question a little late.
pricing is something where you actually charge lower than the cost. And these are two different things.
It is. These are two different things. How? Because, in your lordship, my apologies for that wrong example. Now, what is happening is the practice of the flashcard app, the price sensitivity does not only limit itself to people who are richer and who can afford. It is also to the extent that those people who cannot afford, will offer them a price which is lower than the cost. Now, what is happening is it is misleading the consumers into believing. Uh, I'll not venture into that. But I'm just saying that this analogy stands in the sense that price sensitivity is gauged, and both the rich and the poor are targeted. Uh, Your Lordship, furthermore, with regards to how it amounts to an unfair trade practice, this price discrimination and how it finds its place in Consumer Protection Act, I would like to answer that question in the rebuttals, if that is possible. Much obliged. Now I would come to my final issue, which is regarding which is regarding how can transparency be offered, or whether consumers have a right to transparency in algorithmic decision making of the app. Your Lordship and your Ladyship, it is submitted that algorithmic decision making is a very novel thing, and it is a very novel thing, but it is prone to biases. So, and it does not have any accountability in that sense. So, it is prone to biases, as we have already seen in various cases where Amazon has discriminated in its hiring practices, and it had to give up its software. So, in this scenario, what happens is the bias comes in inadvertently. Now, if a person does not have any way to review that algorithm, that would create a wall which would violate their right to transparency. Now, transparency is something.
Sorry to ask the same question again. Where did you read this right of transparency in the statute?
Your Lordship, it does find its place in the Puttaswamy judgment. In the statute, I'm not sure in which.
Transparency that a consumer has about pricing algorithms is derived from Puttaswamy.
No, Your Lordship. This algorithmic decision making is a very novel thing. It does not find place in the Consumer Protection Act. Now, this is a constitutional question, which is the fifth issue, and it has to be answered in that sense only, in my opinion.
Also, go to assist us for us to be able to answer. We want your assistance.
Your Lordship, it violates consumer rights, and how it violates that, I'm just noting down these questions and will answer that a little later. But it does violate consumer rights. Your Lordship, towards the end, my only submission that remains is I would like to conclude this issue from number 5, wherein I would state that right to transparency is an essential right found in Article 21, and it has to be honored with regards to algorithmic decision making. Now, various countries which are having these softwares, what they are doing is they are employing an audit system, an independent auditing of the algorithms, so that at least that much transparency is made out, where we can predict as to how much is to be charged, where with the consumers can at least predict how much the prices would range, and therefore that much transparency would fall within the purview of the consumer rights, and which I would be answering in the rebuttal round at the as to in which part of the consumer rights this transparency falls. If the court is satisfied, the council would now concede the floor to my co-counsel. I do know that. But with the, but Ye- this this honorable court's discussion is wide enough to include an answer in the rebuttals. So how about I help my speaker to in answering that question towards the end of the prayer clause or in that way? Mm. Your Lordships, but Supreme Court has power enough to do anything. Apologies. Apologies. It can if it is an interest of justice. Ignore the law in the sense the legislation, not the law of the land, which is the constitution. Supreme interpret, but it can also do mischievous interpretation. It was in the sense that a legislation, if it has to suppress a mischief, then the court can broaden the interpretation. Apologies. And I would now like to concede the. Okay, I'll give it a read. Much obliged.
Council seeks permission to approach the dais. Much appreciated, Your Lordships. Your Lordships, I'll be dealing with issues number 1, 2, and 3 as stated by my co-counsel. I'll get into issue 1 directly. Issue 1 raises questions upon whether the policy, that is the policy on foreign direct investment, is was violated by the appellants in this present case by effectively operating as an inventory-based model in disguise. Your Lordship, the FDI policy in question here is the 2017 to 2020 consolidated FDI policy, and I would request the court clerks to hand over the copy of the same to the bench. The policy here defines the legal limits and the conditions for the receipt of FDI by an e-commerce entity. Your Lordship, the policy recognizes two models. That is an just a second, Your Lord. Yes, Your Lord. Yes, my Lord. I have it. Yes, Your Lord. Yes. Uh, the first three lines says that the mere issuance of notice would not warrant writ interference. Your Lordship, it is here that I contend I am for the respondents, I am the stage here. What we are in fact contending is that the appellants have jumped the gun. They could have easily answered the adjudicating authority. Not the ED, Your Lordship. The not the ED, Your Lordship. That is the appellants here have jumped the procedural structure that is there, and they have moved to the High Court on a violation of a writ, violation of a fundamental. Yes. Yes, Your Lordship. Very well. Lordship, it is the appellant's argument that there was a violation of fundamental rights in the High Court, which the High Court had held that was not the case. They have now chosen to appeal it under the powers provided under Article 136 of the Constitution, that is a special leave petition. The Supreme Court had chosen to
maintained that have admitted the same, and that is how I have come in front of this court, and that is how the jurisdiction is vested in this court to exercise in this present instance.
Everything that you said until the last sentence is right. So you have clearly explained how these proceedings emanate.
Yes, Your Lordship.
That's the beginning point of our question. If the High Court has said that there is no jurisdiction with the Constitutional Court and therefore writ should not be issued, how do you assist us as a counsel appealing for the respondent state whether we have jurisdiction, whether we should exercise jurisdiction, whether we should not exercise jurisdiction?
Your Lordship, it is the contention of the state that the High Court, that the Supreme Court at this instance should not exercise power under 136 and should not exercise its jurisdiction. Upon the question of maintainability, I submit that the Supreme Court's powers under 136 should not be exercised until and unless there is a clear-cut and explicit violation of Part 3 of the Constitution which enshrines the fundamental right. If Your Lordships allow me, I would like to submit upon the merits how there was no violation of fundamental rights.
This is not Article 32. This is Article 136. Does Article 136 apply only to violation of a fundamental right?
Your Lordship, it is the appellants who have approached the court under Article 136 alleging violations of fundamental rights. Hence, my submissions will be in response to the same. Are in response.
Jurisdiction under 136, this court should not exercise.
Yes, Your Ladyship.
Does that mean that necessarily there has to be violation of fundamental rights for this court to exercise jurisdiction under 136?
No, Your Ladyship. The answer also, the powers under 136 can also be exercised as and when the High Court has erred or has not applied the law as it should have been. So, in this instant case, the High Court's findings have been absolutely correct. The finding on facts have to be submitted in front of a specialized body, as has been elucidated in multiplicity of cases, particularly in the example of NGT Suomoto case, wherein tribunals are held to be creatures of statute. So the tribunal here in this question is the ED, which deals with FEMA violations and FDI policy violations. The fact-finding exercise has to happen at the lower levels of where the adjudicating authority sits. It is in the light of the same, we have to look into the facts that process itself has not completed. The appellants have moved to the High Court on supposed violation of certain fundamental rights, and when the High Court had rejected the same, they have now in front of this apex court, now in front of the Supreme Court under the guise of on the same grounds, and not been able to demonstrate how the High Court has erred in holding that they have approached the High Court at an earlier stage. So that remains the crux of the submissions under issue 1, upon the jurisdictional issue, Your Lordship. I'll move to the merits if the Lords allow. Much obliged, Your Lordships. So upon the violation of fundamental rights, particularly on Article 14, I'd be submitting it is the case of the respondents that the FDI policy, as I've submitted to you, prohibits. In page number 50, the first paragraph, the first line in fact, prohibits that there is a restriction on use of FDI in inventory-based models. It is the claim of the appellants here that they are a market-based model. We contest that because during the year of 2022, they have breached the 25% threshold that remains, that has been put in place by the FDI policy. Now, what exactly is the 25% threshold? Is that the total purchases would amount to total purchases of a vendor if it breaches 25% from a particular marketplace entity, that is a particular marketplace e-commerce entity, then the model would shift from a marketplace, it will morph from a marketplace model to an inventory-based model, wherein the marketplace entity will have set to have inventory control over the vendor, control over the inventory of the vendor. It is here that I contend, as till the point the FDI policy is not struck down upon the court for being fundamental, that is unconstitutional, not violative of fundamental rights, the law remains in place. The law has to take action here, and the law posits that as and when this threshold is breached, you become an inventory-based model, and inventory-based model is entirely prohibited. This amounts to violation of FEMA, particularly the non-debt instrument rules of 2019, section 6A, and particularly the penalties under section 13 of FEMA would also apply. It is at this point, Your Lordships, I contend that till the point that this law remains in place, it should apply as it stands.
Council, how do you meet their objection that what happened in 2022 was because of exceptional circumstances which were arising because of COVID and other reasons? And that was a stray incident, it was not something which had any pattern.
Your Lordships, I contend upon this very question that the the legislative intent behind the FDI's ban on inventory-based model has to be respected. Why I say so is because on similar regulations, on FPI regulations, on transforming of FPI regulation, investments into FDI regulations, particularly 27 of the FPI regulations, the Master Circular says that, and I'd like to read it out. I'll paraphrase it for your lords, for sake of brevity. The FPI regulations and the Master Circular stipulate that investments made by an FDI along with its investor group shall be less than 10% of the total paid up equity capital. Furthermore, breach of prescribed limit is required to A, divest the excess holding within 5 trading days from the date of settlement of the trade. Lordship, this is to prove that when the legislature has felt that there needs to be saving clauses to such policies, it will be spelt out by the legislature as it is. The force majeure event that the appellants are trying to shield themselves behind does not apply in this instant case. Your Lordship, I'll give another example, particularly with regards to how legislative intent has been interpreted. Your Lordship, when it comes to appeal in front of the NCLAT, the statutory limits provides for 30 days and an extension of 15 days. It was held by the Supreme Court that even an extension of single day would lead to the violation of the legislative intent, and why no longer period was not been given to file an appeal. So Lordship, even if there is court holiday, so that sort of a relaxation is not given. So Lordship, it is at this point that the force majeure argument of the appellants falls flat, because they cannot hide behind it when the legislators have exclusively excluded it, has directly excluded it, and when in similar regulations they have allowed for the same.
The example that you've given is not appropriate at all, because as far as filing of appeals, etc., is concerned, that's purely procedural, where the courts have always been liberal. But
Ye-
what you're talking about is violation of substantive law.
Your Lordships, it was merely persuasive in furtherance of my arguments, as and when the legislature provides something explicitly, it also excludes what it wants to exclude exclusively. So in this instant case, my example towards the NCLAT was merely persuasive in nature. However, I believe my arguments with regards to FPI deals with this issue directly, wherein upon similar issues, the legislative in its wisdom has provided for certain savings, if I may say so, Your Lordships. So I believe that would be in furtherance of my arguments, that there cannot be an argument that the force majeure clause, particularly no finding of violation of Article 1419 or any of the other fundamental rights enshrined in Part 3, should be allowed, Your Lordship.
So today they are back within the limit, right?
Yes, Your Lordship.
So today it's fine.
Your Lordship, whether they are back within the limit, or till what extent the continuation of their offence happened, the violation of the FDI policy happened, is matter of adjudication in front of the adjudicating authority, and it is I cannot answer in the affirmative or the negative, because it is not found in facts as of yet, Your Lordship. Your Lordship, if I may proceed to the further submission. Much obliged, Your Lordship. Your Lordship, I now would move upon issue 2. Issue 2 places the question before the court whether the government proposals restricting ultra-fast delivery claims like 10-minute guarantees and imposing minimum pricing on essential goods sold violate constitutional rights under Article 14 and Article 19. Upon this question, I first would like to take the courts through the legislative background, the background of the litigation, if I could, Your Lordships, so that I have a better standing, Your Lordship. So, Your Lordship, there was a challenge there was a writ petition filed in the Nataka High Court, with regards to the draft proposal of the central government, in which the petitioners, the appellants, the the appellants were the original petitioners in that case. They led the class in the challenge behind that writ petition, and particularly the the averments in that were with regards to that there was a breach of Article 14, that the rules imposed upon them, particularly imposing minimum online pricing, would result in violation, and not placing those same restrictions on larger brick and mortar players would result in violation of Article 14. And furthermore, that the restriction on their advertisements of ultra fast delivery services would violate their rights under Article 19. The Nataka High Court had what the Nataka High Court had said. It gave a nuanced judgment. They said that the right and the right to trade the court held was not absolute, and that innovative businesses can be subject to certain regulations. Now, what is the question in front of the Supreme Court today is there was a cross appeal to the judgment of the Nataka High Court, wherein the questions regarding the holdings of the Nataka High Court with regards to maintenance of status quo is what is being contested by the state in this instance case, Your Lordships. At the very offset, I would like to reiterate the point that the draft proposal here is in the nature of a draft. It has not completed its entire journey of having been formed into a law. As a society, we have decided upon certain rules as to how we are going to govern ourselves. We are going to govern ourselves by rules that we set ourselves and we give ourselves. For that, we have elected a parliament. A representative democracy is what is at place, where our legislature forms certain rules, and it is to be executed by the executive, and the judiciary forms its parts in balancing the two and the protection of the fundamental rights. Your Lordship, in this instant case, the law itself is not law under the definitions as which has been provided by what would constitute law under Article 13(3). It is on this very ground I contest that the observations of the Nataka High Court saying there are prima facie violations of Article 14 would amount to a judicial interference in the action in the state's exercise of what is its domain. Nothing in the factual matrix points to the fact that there would have not been any sort of an stakeholder meeting of sorts, wherein we would not take the appellants with ourselves to solve the issues better. Lordships, furthermore, the entirety of the allegations from the appellant side, even in the High Court stage, was all based on the conjecture that the police advisory was in the nature of a coercive action against them. That is not found in facts. The police advisory is based upon the idea that these drivers, and not merely upon the idea, Your Lordships, it is most definitely can be averred that the riders, to meet certain demands, do ride at excessive speeds, and it is the duty of the police to ensure that these overspeeding overspeeding is not done in the spirit in the to fulfill demands of the consumers who are using the platform, Your Lordship. Are my lords with me on this issue? Your Lordships, I'll refer to my Moot Court memorial on this. Your Lordships, particularly yes, Your Lordship.
Saying that you are trying to achieve something by using impractical speeds. Is it undefined?
Your Lordship, what it strikes at is the legislative competence here. Do we have the power to I contend that the state has the power to define what would mean as a excessive speeds.
It talks about an impracticable speed.
Your Lordship, the power Your Lordship, the Bolur City's police advisory, I reiterate, the advisory was against publicly promising impracticable delivery speeds that can endanger traffic safety. Yes, Your Lordship, I'll get into it. So, Lordships, what can be defined as impracticable would be in the exclusive domain of how the police defines it, because the maintenance of traffic safety is in the domain of the is in the domain of the police. The traffic police has to ensure that the what would constitute an impractical speed, that speed limits within the city are to be decided by the state itself. And for this, I would place my reliance upon a case law found in page number 16 of my Moot Court Memorial. If I could direct my Lord's attention to page number 16, paragraph 13, Your Lordship. Within it, I read the case. The name of the case is State of Madhya Pradesh versus Nandalal Jaiswal, wherein the court held the very court held the court cannot strike down a policy decision taken by state government merely because it feels that another decision would have been fairer, wiser, more scientific, or logical. Your Lordship, what would be impractical can only be defined by the state in this instant case, and what it would be probably be defined, not probably, would be defined by the state as and when such an issue comes up. And we have already clarified that this is an advisory to the public to not drive at impractical speeds. Lordship, within the city folds, there is a lot of traffic. There are other issues other than traffic also which impedes driving at high speeds, but one of which is the narrower roads. Particularly, it is impractical for a person to ride within a narrow street at 80 kilometers per hour to meet the demands of the society, meet the demands of the consumer, Your Lordship. Lordship, Your Lordship. Lordship, that can only be the case wherein such a definition is required. If it is understood that the impractical speed, as in layman would understood it, because the primary rule of interpretation is that it has to be interpreted how it is to be understood in the dictionary meaning, Your Lordship. If we are to go into what would constitute impractical speed, the traffic regulations would never be
Counsel,
implemented.
there are two problems here.
Yes, Your Lordship.
The first problem is, as my learned brother already points out, if you leave something which is vague,
Yes, Your Lordship.
you're basically leaving all these gig workers at the mercy of all these traffic police persons, where the amount of corruption that happens, the court can take judicial notice. And therefore, you're leaving all of them at the mercy of these people within the 10 or 15 minutes that they have to do this last mile delivery. The second bigger problem, please have the Moot proposition at page 6.
Yes, Your Lordship, I say.
The policy that you propose is under the e-commerce rules.
Yes, Your Lordship.
Correct?
Yes.
Now, if you see the power that you have to make rules under section 101 of the Consumer Protection Act,
Just a moment, Your Lordship.
these e-commerce rules are under section 101 ZZ, which only provides, I'll read for your benefit, the measures to be taken by the central government to prevent unfair trade practices in e-commerce.
Your Lordship, could you please give me the section again?
If you please see page 6,
Yes, Your Lordship.
the guidelines in question, even the draft,
Yes, Your Lordship.
was under the e-commerce rules under the Consumer Protection Act.
Yes, Your Lordship.
Now, under the Consumer Protection Act, if you take a look at the e-commerce rules, those are on the basis of the power that the central government has under section 101. Subclause ZG.
Yes, Your Lordship.
If you see ZG, please read out.
The measures to be taken by the central government to prevent unfair trade practices in e-commerce, direct selling under
So
section
the
95.
statute says you can only formulate rules to prevent unfair trade practice.
Yes, Your Lordship.
So how is this an unfair trade practice?
The unfair trade practice as regards to the draft itself, Your Lordship.
To have the minutes of delivery decided by the central government, or for the central government to say that you cannot offer delivery within 10 minutes.
Your Lordship, the answer to that question remains in the fact that the
Counsel, before you attempt to answer, keep in mind what has fallen from the bench. My learned brother already pointed out that, and so did the Chief Justice, that you have under your traffic police powers sufficient powers to regulate speed, sufficient powers to regulate traffic or the well-being of people. Now here, you want to invoke your power under section 101, which provides for e-commerce rules to be made, and central government has a power to prevent unfair trade practices. On a prima facie reading, I am not with you that you have a power to stop delivery time using or invoking this power.
Very well, Your Lordship. To answer Your Lordship's question first, the interpretation of impractical speech would come into question when there is not a question of the police in fact trying to ensure public welfare, and the very nature of the advisory nature of the advisory nature of what has been released by the Bolur city police would ensure that such an interpretation issue will not come into fore. Because say for example that the state police tomorrow puts out a guideline that do not drink and drive is one of the repeated messages. So if I do drink, you can drink a certain amount of alcohol. If I am to get into what would constitute not drinking, what would constitute drinking, what percentage, if a beverage country is how much percent, if we get into that sort of a questions, then that would impede the executive's power to. Yes, Your Lordship. Perhaps the example may have been bit crude, but but the point I was trying to make is that if there is a power given to the to the executive to exercise so that the larger public welfare is will maintain, and if a question of interpretation comes to the court, the question will revolve around the fact between a balance between the two, as in if the powers exercised are too excessive, and that has not been the case, Your Lordship. The contention of the appellants was not whether the traffic police has correctly exercised his power or not. However, I'll take your Lord's question to that, as in the exercise of power under Consumer Protection Act is not vested in law. So, Your Lordship, the rules that have been drafted with regards to the consumer, with regards to the section 101 ZG, that it is to prevent unfair trade practices. The very word guarantee in their claim is what causes the issue, Your Lordship. Guarantee effectively means that they are saying that this is going to happen. The very word guarantee has to be interpreted as is seen in the dictionary meaning, Your Lordship. Why I say so? Because a common average rational man would not be able to differentiate that this is something that they are saying for the benefit of a marketing tactic, Your Lordship. It is the contention of the side respondent, and I contend strongly at this point that it is impossible for somebody to delineate between the two sets of issues here, as in what is an market.
What legal injury does that person suffer? See, when I give a guarantee that this TV is going to run for 36 months, that's a warranty, and it does not, then there is an injury that you suffer, that the TV is bad and I must repair it and give it back to you as long as it is under warranty. Correct? There's a legal injury.
Yes,
But for a user who goes to these platforms, assuming enticed by the fact that I'll get it in 10 minutes, what heavens did fall if it came after 10 minutes?
Your Lordship, the heavens did fall in this case. The enticement here is the problem, Your Lordship. Whether or not they suffer, and whether or not they suffer an injury is to be found in facts in later course, which is to be decided by the consumer forums, Your Lordship. The person who has not been delivered goods within 30 minutes, as is the popular claim for Domino's for many years now, have been acted upon and have been fulfilled, in fact, by Domino's, wherein they given free delivery. Not only free delivery, free products if the pizza is not delivered in 30 minutes. Yes, Your Lordship, and Your Lordship, on this issue, I answer that the unfair trade practices here is the misleading nature of the advertisement.
Misled is the question you ask yourself. Who is being misled? A consumer who lives in a particular corner of the city knows that depending on daily traffic conditions, it would not be 10 minutes, but maybe 12 minutes, maybe 15 minutes.
But Your Lordship, the conduct of the appellants does not indicate such. I come to this conclusion from the very fact that they're willing to change the 10-minute guarantee. It is not a core part of their business. Your Lordship, this is a mere marketing gimmick which they're employed. If they're willing to so willingly change, even if it is the High Court's order, they could have challenged it in the Nataka High Court itself, Your Lordship. Coming to the Supreme Court is merely a delay tactic employed by the appellants so that this issue is litigated around and around, and there is no larger questions that they wish to raise upon, Your Lordship. Violation of Article 14 and 19 on a draft is unheard of, even if the Supreme Court exercises its powers under 142, which I bow down to the courts. The courts do have jurisdiction under it to hold extraordinary steps in the interest of complete justice. However, to do so in this instant case, when a law is not been formed, would result in grave prejudice to the state, Your Lordship. And that is the soul of my arguments, Your Lordship. If, due to the paucity of time, if my Lords allow, I'd like to move on to issue number 3 that relates to violation of competition law, Your Lordship. Do I have my Lord's permission? Much obliged, Your Lordship. Issue 3, Your Lordship, deals with the question. Issue 3, Your Lordship, deals with the question whether the flash retail. Lordships, if I may I have a little bit of extension over the 2 minutes that I have remaining to submit the issues? Much obliged, Your Lordship. Issue 3 in this issue 3 deals with the question whether flash retail engage in predatory pricing and anti-competitive by entering into. I correct myself. Whether flash retail engage in predatory pricing by selling below cost to eliminate competition and entered anti-competitive exclusive supply agreements that would amount to abuse of market dominance. Your Lordship, it is the primary contention of the state here that an order to the DG under 26(1) is not appealable under the provisions of the Competition Act, Your Lordship, of 2002. Herein, the legislature had provided for certain orders to be challenged, one of which is a 26(3) order, Your Lordships. In the absence of a clear option provided to the litigants to appeal an order, what the appellants here have done has instead chosen to file a case in the High Court in this instant case, Your Lordship, and then they have filed an SLP for the same. Your Lordship, the very fact remains that this SLP should not be maintained, primarily because this is an administrative order, Your Lordship. The administrative order here in question is with regards to the fact-finding exercise of the commission to come into a discussion of what is the relevant market, what would be the relevant product market, what would be the relevant geographic market, which would constitute the definition of what would the relevant market be.
Mumbai High Court says, citing Supreme Court's rulings that court may not readily stop investigations by regulators. Do you have any such judgments?
Lordship, if I may be given a moment of indulgence, Your Lordship, I'll provide you with the case. Your Lordship, one such fact-finding exercise that is conducted in terms of specialized body would be the Narcotics Control Bureau. Lordship, I understand that is a penal.
Is there a specific judgment from the Mumbai High Court simply says that there are several Supreme Court rulings on this issue? Can you give us any one specific ruling, any judgment that you rely on?
Lordship, I have not placed reliance upon any judgments as such, Your Lordships. Your Lordship, the very fact that we have emerged victorious in the Mumbai High Court. Your Lordship, it is not I who had appeared in that matter. I was briefed of this matter just yesterday night, so I come prepared with little preparation in front of this, because although I do apologize, I understand the importance of arguing in front of a constitutional bench, Your Lordship. However, yes, Your Lordship. So. Your Lordships, I'll only contest upon the merits if the court is. I will not contest upon the merits of the predatory pricing and the exclusive supply agreements if the jurisdiction submissions satisfy the Lords. Your Lordships, if I may I please place the prayer clause on record. In light of these issues raised, arguments advanced, authorities cited, may this honorable court be pleased to adjudge and declare that the Flash Model's business model is in violation of Sindhu Pradesh's FDI policy by effectively running an inventory-based model instead of a marketplace one, that the government's proposal restricting ultra-fast delivery claim, like the 10-minute guarantees and imposing minimum pricing on essential goods, do not violate constitutional rights under Article 19 and Article 19(1)(g), Article 14 and Article 19(1)(g). Thirdly, The flash retail engage in predatory pricing by selling below cost to eliminate competition and use algorithmic pricing strategies that amounts to tacit collusion and abuse of market dominance. Fourthly, the flash retail's app design practices, dark patterns, misleading 10-minute advertisement and personalized pricing and discounting strategies constitute unfair trade practices under Consumer Protection Act 2019. And fifthly, the flash retail's users have a right to transparency in algorithmic decision making, having access to relevant algorithms for review, and that flash retail practices infringe on rights under Article 21, and or pass any other order, direction, or relief that the Honorable Supreme Court may deem fit and proper in the interest of justice, equity, and good conscience. And for this act of kindness, the respondents shall be duty bound forever. Pray. Much obliged, Your Lordships. It was a pleasure and privilege to argue in front of this bench today. Thank you.
I now request all the participants and students to please move to Julie Auntie's canteen for high tea. And I request the student representatives to please usher the judges near the gazebo for high tea. Thank you. All the participants and students are requested to report back to the Audi by 7 for the valedictory ceremony.